Hello and welcome to Legally Speaking with me, Tarun Nangia. We continue our discussion on our series titled India's Top Litigators. And we have with us Mr. Ryan Karanjawala, Managing Partner of Karanjawala and Company today, which is one of India's leading litigation law firms at the city of Delhi, namely the Supreme Court of India, Delhi High Court, and other forums, NCLT and CLAT at the city of Delhi. And of course, today he's going to speak to us. His client list, as you all would already know by now, reads from the who's who of India. As I would like to say, from the biggest industrial groups of India and London, namely Tata Group and ArcelorMittal, to the biggest superstar one of the biggest superstars of the world, that is Shah Rukh Khan. He's represented them all. And today he's going to speak about that and a lot more. Good to see Mr. Karanjawala. And first of all, many congratulations. You recently won the top litigating law firm, the Law Firm of the Year award at the Economic Times Awards, if I'm saying it correctly. Many congratulations to you for that.
Thank you. Thank you, Tarun.
And so, of course, if the Economic Times gave you an award for the top law firm, the litigating firm, the first thing I would like to mention that paper is full of companies. In a sense, they report on companies. And which are the companies that in the past few years that you have done cases for? Of course, the ones I know, but there were many. Could you share and name a few cases?
So Tarun, we frankly litigate across the board for many corporations. And there are, all the big names, most of the big names are there, and God has been very kind to us. But rather than just rattle off a whole string of companies, I represent him, I think it's better that I just isolate in recent times and recent vintage some important cases that we have done which are still in the public domain and where people's memory still sort of recollects those cases. So one, of course, on the individual side, on the criminal side, was the case of Shah Rukh Khan's son, Aryan Khan. We were lucky in getting him bail from the Bombay High Court, so our firm was there and we were involved, and that was a very high-profile, important case, both for us and obviously something that was being watched by most of the country. As far as corporate battles go, then we've been in 2-3 of the big recent corporate battles. One was a few years ago. We represented throughout, from the incipient stage till the end, where we succeeded, the Tata Group against Cyrus Mistry. So that was one battle we represented. Another battle was under the new IBC code. Probably the largest stake battle under that code was the one in which ArcelorMittal took over SR Steel. So our firm again represented, along with Rajiv Luthra's firm, represented ArcelorMittal. Also, it's important to point out that in the Tata Mystery War, again, we worked with another firm, Shardul Amarchand Shroff, because very often in big litigations, 2 to 3 firms collaborate on behalf of a client to sort of take the matter further. Another such example of collaboration was when we worked with AZB, Zia Modi's firm, to acquire Bhushan Steel on behalf of Tata Steel. So these are some of the litigations which have been high profile, which we have appeared in recent times. A few years ago, again, when Jack Dorsey, who used to head Twitter, was prosecuted, our criminal team took over that matter and again represented him and successfully brought the case to a happy conclusion. So these are some of the recent cases of high profile that our firm has appeared.
In fact, the whole world, the whole of corporate India, if I may say, corporates from the whole world, be it Washington to London to Japan, they were witnessing the Ratan Tata or the Tata Mystery battle that you successfully won for the Tata Group. Would you count that?
I successfully means I with a group of top counsels. I mean, that was a litigation where we had all the top counsels in the country. We had
which all counsels did you work for?
We had Harish, we had Manu Singhvi, we had Mukul Rothgi. Everyone was
you engaged all of them,
and a host of junior counsels. everyone was representing the Tata Group in
But you
various
engaged all the three top
companies.
counsels for this, Harish
Yes,
Salve,
yes, yes,
Mukul
yes, yes,
Rohde, and
In fact, one
Singh.
of the things that I did manage to do was that in the first 24 hours or 48 hours, when the litigation, when after Cyrus got sacked, I sort of retained and blocked almost every counsel that was available. And that, I think, certainly was something that came to good stead, because that's how.
Is this part of a litigation strategy that the top law firms get, that, all this also counts?
See, a litigation strategy begins right at the very beginning. And seeing that your team is an adequate team is always part of a good litigation strategy. Now, the problem is that in India and everywhere in the world, counsels don't come cheap. So if you want to block them off, it's a very expensive process, and not everybody can afford it. But this was not a matter in which there was going to be any penny pinching, I think, on either side's part. So, I mean, we just took advantage of that, or we utilized it to its full impact, and therefore we were lucky in being able to secure. I mean, I'd also retained Kapil and a lot of other counsels also, who I'm not naming. So we were able to secure and ensure that if Cyrus ever went to court, which he ultimately did after a month or two, we would be well represented. Our side would be adequately represented. That was something that we had in mind when I made that suggestion, which was readily accepted by the client.
Now, since your law firm is signed, as I have known, has been a Supreme Court law firm for now decades. Uh, we counted some of the recent clients, ArcelorMittal and Tata's and many others. If you could name a few cases that you've historically done that have been big, say in the 90s and late
So,
80s and
our
2000s.
firm, as you know, Tarun, started in February 83. Now, firm is a word, because at that time it was really, when Manik, my wife, and I started what later on became Kalajawala and Company, it was really a mom and pop shop. There were two of us on the Barsati of my father-in-law's house in Marani Bagh, and one clerk, and that's how it all began. But we were very lucky in one thing. If I were to look back and say, okay, what were the things that made you stand out, and what were the things that made you more successful than the other firm? Why did things go better for you? I think one of the things that I have to credit is that we were swimming at the same time in two parallel streams. So one was that we constantly did what you would call the bread and butter work of a legal firm. Ordinary matters. In the old days, it was landlord tenant. Some tenant was being evicted. Some landlord wanted the eviction, or labor management. All the small, or some small land acquisition, stuff like that. But we constantly did that. So it wasn't as if we only held out that, we'll appear for corporates, or we'll appear for this one. We took every individual client that came our way, because that's always been my philosophy, that never refuse work. So, we took every individual client that came our way. But the difference was that for us, where we got lucky was that every few years, we got one big high profile client, which took us one step up the ladder. So, for example, I just rattle off quickly, because, we don't really want to bore everyone. But so, for example, in 83, the biggest litigation in the Supreme Court was called Swadeshi Politics, where my firm was on record for the Sitaram Jaipuria group. And we had briefed the top counsels of that time and now. I mean, of that time, two of them are no longer here. Mr. Venugopal, who, as you know, became our Attorney General, Anil Diwan, who's no more, and Ashok Desai, who again became Attorney General, who is today no more. All three of them were engaged by us, and that was a very important litigation, which sort of gave us a profile. Then we were fortunate that 2-3 years later, the Indian Express Group, the Nasli Wadia Group, came my way. Then we were fortunate that in the year 87, and this was a big break as far as we were concerned, Mr. VP Singh, who was then the former finance minister and the former defense minister, and later on went on to become the Prime Minister of India, he came to us as a client, and we appeared for him in the Fairfax Commission, the Thakkar Natarajan Fairfax Commission. So that gave us a huge profile, because, when you appear for such high personalities, obviously the cases are talked about, the counsels who appear in the cases are talked about. And that's what really sort of started putting us on a higher and higher pedestal. Post VP Singh coming to power, we got Indian Airlines as a client. And according to me, I think that was the turning point, because that's the stage at which, from becoming a mom and pop store, 2 people, 5 people, 10 people, 15 juniors, we suddenly became bigger because Indian Airlines as a client had litigation in every forum. When you have litigation in every forum, then you need the bandwidth. So I had to hire people. We became a firm of about 25 people, and so that's how we progressed. Then a few years later, suddenly uh, Rupert Murdoch came our way, interacted personally with us, appointed us as the lawyer for what was Star TV, and we still do all Star TV's work. So a lot of media profile came our way. After that, Lufthansa came in the fight that they had with Modi Luft. Then the Tata Group came in some diesel ban issue in the Supreme Court, and so on. And then it just went on, and things just kept on growing. And then in the year 2000, we had WLL, which was also a very big litigation. If after Cyrus Mistry, I think the biggest litigation that we have seen in real terms between two sides, it was WLL, where the cellular operators of India took on the Ambanis for their entry into telecom. So that was a huge litigation. And at that time, I came to a particular crossroad. Something happened, in which I'll share with you. Two firms. One, Rajiv Luther's firm, uh, he's no more, and the other, Amarchand Mangalas. Both of them came our way in the sense of they suggested that the two firms should amalgamate. Either my firm with Luthra or my firm with Amarchand should amalgamate and become one firm. And while I didn't really spend much time on the Luthra suggestion, I did interact a lot with the shops on the Amarchand Mangalas merger. Ultimately, I decided not to. And the learning that I got at that time was that a lot of people came to me and said, "Look, you have a fairly high profile yourself," which I didn't realize. You yourself are fairly well known. You're doing very well in the field in which you have chosen to be. Stick to that field and you will grow. And it's advice that I took, and it's advice I think that came my way and really sort of benefited us. And then, of course, a lot of other big matters came. The Bombay mill land matter, where the stakes were some 40, 50,000 crores, because, the question of so much mill land being either appropriated by the government or not being appropriated by the government, that came up. Then the Birla Lodha war, where we, for some time, appeared on behalf of the Birlas. And then, of course, other cases just keep coming, which are, one can't now spend time rattling off all the cases that one has done, but this is how life progressed.
One thing I want to know from you is that what is your work philosophy? Because I have seen or I have heard you saying many times that do you do a lot of big matters? Your law firm essentially handles hundreds and hundreds of cases of a single client. So 400 cases, 300. What is that work philosophy that you do every kind of work in a law firm?
So I do every kind of litigation I can do, because we're not equipped to do M&A or capital
You
markets.
litigating.
So we only do what we can do. Yes, that is, if you were to ask me, what is the fundamental essential of a law practice, then I think the answer is found in an old New York musical joke. See, there's a story of a little boy who goes up with a violin in his hand to an officer, police officer on the streets of New York, and says, "Officer, officer, how do I find my way to Carnegie Hall?" And the officer sort of looks down at him, smiles, and says, "Practice." So, the point is that unless you do a lot of work, you really can't be good in what you do, especially in litigation. And I'll give you a reason for it. You see, if you're doing M&A, you can probably do 20 M&As, 30 M&As, 40 M&As, and then have a fairly good idea of everything. In litigation, because you're not only, because the facts are not within one narrow compass, the law is not within one narrow compass. You have to do a lot of litigation to succeed. And if you see the story of every successful counsel also, except, say, with the exception of Palkhiwala, who went away to Bombay House, everybody who has been risen to the top has really risen to the top only by doing a lot of work. And I'll give you personal examples. So I remember when Arun Jaitley stepped down as law officer. And he asked me one day, he said, what do you think, Ryan? How many matters should I take in a day? Two, three. I said, no, no, don't be silly. Don't take less than eight. Because otherwise you just get lost. There are 40 high court, there are 40 courtrooms in the high court. If you're appearing in only two or three of them a day, the judges won't know you. So if you take any top counsel, take any of the top counsels, you take a Salve, you take a Singhvi, you take a Mukul Rohtgi, you take a Sibal, each of them came up because they just did a lot of work in the early stages, took a lot of matters, appeared in every kind of matter, and got into the habit of being able to roll it out quickly and efficiently. Even today, if you look at Singhvi's board or you look at Salve's no longer with us, he's in England. But if you look at Singhvi's board or you look at Mukul's board, 15, 20 matters on an average day is just normal for them. That's how they came up. That's how they grew. And I believe that's equally important for a law firm. That's why I always, I never say no to work. I don't mind, let them pay you less. It's okay because not everyone can afford a high fee. So be flexible on that. But ensure that you do as much work as you can.
So have
Because
you, in a
that's the.
sense, so does Mr. Karanjawala, or have you turned the law firm in a factory model where you can accept large number of cases? I mean, how many lawyers do you keep to be able to?
So you keep every firm keeps the amount of lawyers it needs or a little more. I mean, that's what you normally do. So, I mean, at a given point of time, as I said, we started with two. Today we are over 100 and only in litigation. So that's a lot because, the other big size law firms have branches all over India. We're only in Delhi. We're only in litigation and we're over 100 lawyers. So that's a hell of a lot of litigation, but we need it because, some of our clients, for example, DLF is a retainer client. So for a fixed monthly remuneration, every case of DLF which is concerning litigation, by and large, they send our way. So we have to be ready to handle it and in different forums. So you need the manpower. So that's what we do.
One thing I want to know for you, what changes that you have witnessed in the profession because you've been running this for 4 decades. Anything that you would like to highlight?
Everything. Everything has changed. So let's start with the importance of law as a career. When I joined the bar, which was in 79, that's about 45 years ago. When I joined the bar, law was a career of last choice. People who did well first rushed to become, especially if you came out of the BCom stream. There was a whole lot of people who went to the IAS and all. But if you came out of the BCom stream, you said, okay, I'll do management, MBA. If you didn't get that or you weren't inclined toward that, a lot of people went into CA. We'll become chartered accountants. Law was a sort of a last refuge. Kuch nahi mila to law kara. That's how it was. And it was never a very coveted profession in those days. And even physically, when we joined the bar in 79, I'll just give you 2-3 quick examples. You looked at the Supreme Court and all the courts were in one row. The first 4 courts or the first 5 courts were there, and that was all. That was the whole Supreme Court. Today, of course, it goes up to 14, 15 courts. So, I mean, you can see how many courtrooms there are and how many courtrooms have increased. When you went and stood in the corridor of the Supreme Court looking down at the car park in the morning at 10:15 when you reached, you would find 10 to 12 cars parked over there. Today, 1,000 cars would be parked if there was place for parking. If you go to the High Court, every day I think about 2,000 people pass through 2,000 lawyers pass through the High Court, maybe more. So, law today has become a very coveted profession. And one of the reasons is the fees. I mean, fees have now changed at a level which is just so incredible that you cannot believe it. I'll give you an example. When we joined the bar, in the Supreme Court, the fee of every counsel was standard. It was a fee that Motilal Settlement had laid down years ago in the 50s or 60s as the Supreme Court Bar Association president. He said a senior counsel will charge, and that's applied to everybody, Fali, Soli, everybody. A senior counsel will charge 1140, so 1,140 for an admission and 1,650 for a final hearing. Those days, if you went out of town, maybe you charge a little more. I don't want to take the name of a counsel, but the other day I was just talking to a very close friend and I said, okay, I mean, I was saying on TV the other day that look at the way people are charging. And I said, imagine when we were all together in college, how much we thought, and nobody ever assumed that, you know, people council would charge 1 crore a day. So he sort of grinned and said, don't tell anybody, but now I'm charging two. So, you know how it is. So it's just, I mean, it's just the fees are at an incredible level. But there is a reason for it. The reason for it is the high stake of litigation today. You know, companies, individuals, corporations, they can all be made or broken in a court of law. And therefore, the person, which is the cutting edge of litigation, is always the advocate, is the counsel. Therefore, he can really, if he's at a top level, command fees that 25 years ago also nobody could have ever dreamt would be paid. That's why today law is so much in demand. And also, you see, when we joined the bar, when I joined the bar, there were 3 or 4 firms which were functioning in the whole of Delhi. So, or 5, maybe. There was Rajendra Narayan and Company. The biggest firm, of course, was JB Lalachandji. Then the firm I worked in as a junior, Parekh and Company. Then there was Lalit Basim, and maybe there were 1 or 2 others. That's all. Today, there are about, I mean, you interact with them. You would, I think, countenance when I say that today there must be at least 400 to 500 firms. Am I right? 400 to 500 firms functioning in Delhi itself. So you can see that the whole paradigm has shifted. Law has suddenly become a profession of first choice.
One thing
You
I
know,
want to know that because you successfully ran this firm, turned it to such a large firm, one of the largest in litigation in India. And do you think focus has been one of the reasons or ingredients that you focused on litigation and that's why you became successful or something else?
100%. 100%. I'll give you a reason also. There's not just because I focus. No, I'll give you the real reason. You see, there are smaller firms, but the 2 big firms, I feel, and I may be wrong, there may be others also who are in contention, and I apologize if I'm wrong. But I think the 2 big litigating firms are us and Mahesh Agarwal's firm. That's
Hmm.
what I feel, and do you tend to agree with me, Tarun?
Yeah, as a market perception, these are only two
Yeah.
firms at
So
the
these are
Supreme
the,
Court
no,
today.
let's say we are pure litigating firms, and these are the 2 firms. Now, what is the inbuilt advantage that a firm that focuses on only litigation has over a firm that doesn't focus only on litigation? So you take any other big firm now, take the Amarchans, take the AZBs, take the Khaitans, take everybody else. They are what they call full service firms. So they have different silos which give their clients different kinds of services. So they will have an M&A team, they will have a capital market team,
Fantastic.
they will, which does IPOs and all. They will have a corporate advisory team, they will have a tax planning team, and so on and so forth. It just goes on and on and on, right? Now, the thing to remember is that in an M&A situation, the cutting edge, the person in the forefront, is the partner of the firm. He doesn't go to a counsel and say, yeah, boss, how do I do it? He interacts with the person on the other side and he is the cutting edge. So, necessarily, to get that level of talent to handle a big M&A transaction, you have to pay a lot of money to keep him as a partner. Now, when you're in litigation, sorry to say it, but we are not the cutting edge. The cutting edge is the counsel, the guy who giggled and said, well, actually, I'm charging 2 crores. He's the cutting edge. So the large amount of money that goes into litigation gets taken up by the counsels. The firms get maybe 1/4 of it, or sometimes even less. Certainly, I see no partner being able to charge 25 lakhs for going out of town. So, I mean, we get much less. So, so what happens is, now in a full service firm, if you have a litigation silo also and a litigation practice, you still have to pay your litigating partner at parity with your corporate partners. Now, if you pay your litigating partner at parity with your corporate partners, then what happens is when a client comes to you, you have to charge them a very high charge out rate per hour. Because otherwise, you're not going to make ends meet because you're paying your talent so much more than in order to just keep that talent. As a result of which, your fees are high. As a result of which, a lot of clients go away. A pure litigation firm has this advantage. We don't pay those kind of fees. Certainly my partners don't earn anywhere near what a corporate partner earns. But as a result of which, I am able to drop my fee. I'm able to charge my clients much less. As a result of which, I get a huge amount of work. I get the bulk work, which then trains my people up, which then makes them much better than if they had not been so trained. That's the whole difference. So I
You
hope
mean
I've
this
been
is
able.
a cycle that plays year after year after year, and after that's how you grow.
Yeah. See, essentially, unless you see, you look in our profession, and we have a very big a litigating firm also has a very big role to play. It's not that we should undermine ourselves. You know, we do the preparation, we do the advising of the client, we decide who the counsel should be, we see to it that the counsel is well briefed, we ensure that the counsel appears and reaches, which is also pretty tough. So there's a whole lot of things we have to do. But you can't do that well. You can't do that well unless you've done it very often. In litigation, you have to pass on the baton very often. You know, somebody does this, somebody does this, somebody does this, somebody does this. You won't be able to do it so smoothly unless you do a lot of it. And you can't do a lot of it unless you charge at a reasonable rate. Because otherwise, you'll get few clients. Maybe in 5 arbitrations, you'll make up what a pure litigating firm will earn in 50. But the experience that a junior in the litigating firm will get will be far, far more than the experience that he will get in a non-litigating firm.
Coming to my last two set of questions, and I want to know these from you. One is what came to first. In addition to two, I mean, there are one that I just thought of while you were speaking this answer. Strategy advice. It is said that a law firm's strategy and advice count for a lot in eventually how you are going to, the case is going to be viewed by the courts, because law firms like yours are known for receiving, say, thousands of documents and then turning it into a brief of 10 pages or 5 pages that is then given out to seniors and they argue. So do you think that this whole processing of a lot of documents that then is, channelized to those 10-20 points that actually the courts are given, because courts being the courts, they have less time, and the judges can't go over, so they have to be presented quickly. What is that strategy? Because this is what a lot of people don't know and would like to.
Essentially, it comes down to your experience. First of all, you get every case has a certain amount of documentation. You first have to set aside what you think is unimportant, see what is the case that you want to build, and go toward building that case. You have to advise the client correctly also. Sometimes you just say, it's not worth your while, don't fight, drop it. Sometimes you say, yes, there is a chance, let's take the chance, and then you advise him how to go about it. You have to also ensure that you have an idea as to how much it's going to cost him in the long run and whether he can stay the course. So you also take a counsel according to your cloth, who you can afford, who will be effective. You also have to have a sense, and this is where experience counts,
So
where a litigating experience counts. You also have to have a sense of it's going to come before this judge and you're not going to do too well, or this is the right judge to go. I mean, it's coming before him. Yes, this is the point that will appeal to him. All this comes from just doing a lot of work. That was my basic point. If you don't have that experience, if you go to court once a week, then you're not really going to be a litigator. You have to be in court every day, doing 2 to 3 matters a day, whether you're assisting or you're arguing or whatever you're doing. You have to be there to get that sense of how things work.
Very interesting you say this, because even we know that a lot of civil lawyers, when they become judges, may be handling commercial and civil, criminal matters, and criminal lawyers may be handling civil matters. So the amount of preparation that law firms have to do in order to be able to explain, I think, must be high.
Of course it is. Of course it is. There's no doubt that the bulk of the work is done at our end. There's no doubt about it. The only thing is that it is put across by the counsel. I'm not saying that, obviously sometimes counsels have I mean, the reason why you pay the counsel the amount you pay is because he's superior to you, not only in the way in which he puts across, but the way he thinks about your case. So, of course, there are a lot of differences, and of course, this thing, counsels merit what they sometimes command. But there's no doubt that without the backbone of a well-prepared case, prepared by either very competent juniors or a competent firm, clients would be at a disadvantage. In
And
fact,
you also said one interesting thing, that the law firm will also tell you that given on your financial background and capability, which counsel to go for, because the case goes on for a long time. The client may be
correct,
excited for the
correct.
first date.
And very often what happens is firms like ours and many other firms, very often the person in the firm argues the cases or handles the matters on the unimportant dates. And only for the important days do we take the counsel and so on. You have to, I mean, look, there are many things that go into the mix,
So
and you
that's
have to
also a
be
strategy.
sensitive to them. So
Uh,
that's how it works. That's how
what
it
is the
works.
future of litigation according to you? What are the challenges? See, now we have digital courts.
So we're talking in India. We're
In
talking
India,
in
we
India.
are specific to our Supreme Court, because
So
you largely
okay.
manage High
Well,
Court, Supreme
no,
Court.
we go to every forum. So uh, the two things, the two challenges to the Indian litigative firm at the moment would be, one, what happens if the foreign firm comes in? That's always a challenge. The challenge is because they have huge watches financially, and they can sort of set up. They're not coming into litigation at the moment, but I'm saying, assuming they were, then that would be a direct challenge, because they have. It would be a David versus Goliath sort of situation, because they would have huge financial wherewithal to undercut everybody else in the initial stages, function at a loss, so that they capture the market and then sort of slowly raise the fee once they've captured the market. So that's one worry. The second worry, which is at the moment chaotic and nobody is really very clear about, is AI. What will artificial intelligence do to the actual legal system? Because sooner or later, in 5 or 10 years, you'll probably be able to plug in a set of facts into a machine, and the answer that he would give you would be probably the answer that 90% of the judges would give you. So, will it replace the lawyer? Will it replace the judge? These are things we don't understand yet. But that is something that we certainly have to think it through. These are, I
As
mean,
they said, the future is uncertain and you have to figure out
but
as
it
you go.
always was. It always was. I mean, I've never known at any point of my life for people to say, no, no, this. I mean, I remember Dada Chandji telling me, he said, no, no, and this was what, 35, 40 years ago. He said, according to me, the future in law is labor management disputes. Actually, they don't exist today. I remember when I joined the profession, excise law was the booming law. There are hundreds and hundreds and hundreds and hundreds of cases filed every day on excise. And there were a lot of specialist excise lawyers. Today, they've all evaporated or adapted to some other law. So it's always uncertain. Predictions always go wrong. That's how things are. I think, Tarun, you've gone on mute.
It was a pleasure talking to you. We started our show with your current litigations, namely the most famous for large number of people, or two, the Tata Mistri fight and Shah Rukh Khan, one of the most successful. ArcelorMittal was one of the, because they are the biggest steel producer in the world. That was most famous. Then you also took us through the litigation law firm business. You also shared some strategy inputs with us. And then a lot of other clients and other details. It was indeed a very interesting conversation. We look forward to do this again with you next year. Of course, I know there'll be another 8, 10 big matters to discuss, some big clients.
I don't know. I can't say that, but I
and
hope
much more to talk. And much more
I
to
hope
talk in
what you
2000.
hope is correct, but I can't say. Thank you.
Thank you for your time, and it was a pleasure to talk to you. Thank you.
Thank you.